Good morning, ladies and gentlemen. Welcome to the 2023 Annual Conference of In-House Lawyers, organized by the In-House Lawyers Committee of the Law Society of Hong Kong. This is Catherine Lau, MC of today's event. Before we start the program today, I have a few reminders for you all. Today's conference will be divided into the morning and afternoon sessions. The morning one will run from 9 a.m. to 12 noon and carries 2.5 CPD points. The afternoon session will run from 2 p.m. to 5:35 p.m. and carries 3 CPD points. Please refer to the conference brochure for the program rundown, course outline, and speaker profiles. For those who are joining both sessions in person, please sign in for both sessions in order to claim your CPD points. There will be a short break for each session and a lunch break from 12 noon to 2 p.m. Please make your own lunch arrangements. The conference will be conducted in English and Mandarin and supported by simultaneous interpretation in the 2 languages. We have some devices for those of you who wish to use it here in person. This will be provided on a first-come, first-served basis. You may select Channel 1 for English and Channel 2 for Mandarin. Please contact one of our staff members if you need it. Welcome again to the 2023 Annual Conference of In-House Lawyers. The conference is organized by the Law Society's In-House Lawyers Committee and sponsored by our Pantaloon sponsors, which include China Resources Holdings Company Limited, Lexis, and Thomson Reuters. Our Pantaloon sponsors China Resources Land Limited, Harney Westwood, and Rigels, Link Asset Management Limited, Link's Law Officers, and Withers. And finally, but not least, our digital sponsor, Canon Hong Kong Company Limited. Apologies that I need to update that. Like earlier on, the diamond sponsors should be China Resources Holdings Company Limited, Lexis, and Thomson Reuters. May we now invite Mr. C.M. Chan, President of the Law Society of Hong Kong, to give us a welcoming speech. President, please.
Secretary for Justice, Mr. Paul Lam, distinguished guests, ladies and gentlemen. It is my great pleasure to welcome you all back to a physical format of our annual conference. This is, of course, the 2023 Annual Conference of In-House Lawyers of the Law Society of Hong Kong. May I first express my gratitude again to the Secretary for Justice for gracing us with a keynote speech in a minute. The conference, the In-House Lawyers Conference, has taken on different forms over the past few years, obviously because of COVID. We had reluctantly cancelled the event in 2020 because of public health situation. The conference returned in the following year with all participants joining online. With the tremendous support of the Department of Justice, we managed to introduce our first hybrid conference in 2022, last year, where some of our participants attended the event in person at the Justice Place. I still vividly remember the very cozy location at Justice Place. And I'm delighted that after 4 years, we are now bringing back our physical conference once again, attracting a full house, almost, of audience. To mark Hong Kong's return to the international arena and the world stepping towards normalcy, we are pleased to invite participants from the Greater China region and overseas jurisdictions to take part in the conference this year, online and in person. So please join me in welcoming our guests. In particular, I would like to thank President Gao Zicheng of the All China Lawyers Association, Gao Zicheng 會長, Vice President Zhou Yubing of Dongguan Lawyers Association, Zhou Yubing 副會長, Vice President Zhao Mian Zhang of Jiangmen Lawyers Association, Zhao Min Zhang 副会长, President Karen Chia of Malaysian Bar, as well as delegates from Astana International Financial Center, Myanmar Bar Association, and the Bar Association of the Kingdom of Cambodia, for sparing their time to join us today, in person and online. I was actually the founding chairman of the In-House Lawyers Committee of the Law Society of Hong Kong. So as the founding chair, which was established, the committee was established in 2011, more than 12 years ago. I'm delighted to see that our conference has now developed into a regional event, gathering legal professionals around the world to exchange ideas and network with one another amidst the ever-growing in-house community, which today consists of over 4,000 members, or almost 1/3 of the Law Society membership. My gratitude to my successors for embracing my vision of strengthening the in-house sector in our profession and bringing our flagship conference to new heights every year. Last year's conference was themed The Corporate Connector, highlighting the expanded roles of in-house lawyers as connectors within their companies. As in-house legal teams play an increasingly significant role in business operations, the responsibilities of many in-house lawyers have evolved and extended beyond functional issues to shaping the strategic planning of companies and fostering business growth, which require understanding of the macro environment. This year's title, of course, is From In-House Connector to Super Connector. Under the one country, two systems, Hong Kong has always been a unique business hub connecting the mainland and the global markets, helping mainland enterprises go abroad while attracting international enterprises and capital into the region. The 14th five-year plan further demonstrates the central government's unwavering support to Hong Kong by establishing the positioning of Hong Kong in the overall development of the country, among which Hong Kong is supported to strengthen its status as an international financial center, Center for International Legal and Dispute Resolution Services in the Asia-Pacific region, as well as developing into a regional intellectual property trading hub. As in-house lawyers, we all have a role to play in facilitating Hong Kong's role as a super connector, bridging the mainland with the world. In today's conference, our speakers will explore how in-house lawyers and the legal profession at large can seize the immense opportunities presented by strong national support and develop from a corporate connector to a super connector, promoting the strengths and competitiveness of Hong Kong to the world. I very much look forward to benefiting from their insights. On this note, I would like to thank all esteemed speakers for sparing your time to be with us today, our sponsors for your generous support, and the In-House Lawyers Committee for putting together today's program. I, of course, cannot finish by not thanking all of you as participants to attend today's event physically. May I wish you a fruitful conference, and thank you for your attention. Thank you.
Thank you, President. It is our greatest honor to have Secretary for Justice, Mr. Paul Lam, to be our keynote speaker this year, despite his very, very busy schedule. Without further ado, please join me in welcoming Mr. Lam. SJ, please.
President of Law Society, CM Chen, distinguished guests, ladies and gentlemen, good morning. It's my honor to join you all at this very special event organized by the In-House Lawyers Committee of the Law Society at the Hong Kong Convention and Exhibition Center. And as some of you may recall from my sharing at the conference last year, I found this conference particularly relevant to myself, given the in-house nature of my role as the Secretary for Justice. My department, the Department of Justice, is the largest employer of in-house counsel in Hong Kong. And having been in this position for slightly more than a year, I'm becoming increasingly convinced that to excel as an in-house lawyer, knowing the legal options is just the very first step. And very often, we have to take one step further to put the legal technicalities aside for a moment, step into the shoes of our lay clients, and look at things from this perspective, so as to come up with the most suitable solution, and more importantly, to be able to convince them that it's indeed the most suitable solution. This job is by no means easy, and here I would like to salute to all in-house lawyers. You all have been doing a wonderful job. Now, the theme for this year is in-house lawyers being not only an in-house connector, but also a super connector. You, as in-house lawyers, are known for your role as in-house connectors, who serve to enhance corporate governance and compliance, avoid disputes, and handle disputes if they do arise. Yet the scope of influence does not stop there. As I emphasized last year, you are indispensable members not only of the Hong Kong legal community, but also Hong Kong as a whole. You are in fact a super connector, helping your employers decide whether to move or expand their business to Hong Kong. You may also take part in deciding where a business should be headquartered, what should be the governing law of the contracts that your employees are negotiating, where and how any dispute arising out of this contract should be resolved, and if necessary, which legal practitioners should be engaged. My goal today is to show you how you may capitalize on the unique advantages of Hong Kong when performing your role not only as in-house connector, but also super connectors. Hong Kong is, of course, an international legal service and dispute resolution hub, and we have a diverse pool of legal talents. But a very unique, and perhaps the most unique advantage enjoyed by Hong Kong is the substantial opportunities offered by the principle of one country, two systems. At the 25th anniversary of the establishment of the Hong Kong Special Administrative Region last year, President Xi Jinping made crystal clear that the principle of one country, two systems is a long-term policy that must be adhered to. I will certainly go beyond 2047. This means that Hong Kong will remain as the only common law jurisdiction in our country, China, bring along with its fundamental features such as the rule of law and the independence of the judiciary. The National 14th Five-Year Plan, also mentioned by President Xi in his speech, explicitly supports Hong Kong's development into a center for international legal and dispute resolution service in the Asia-Pacific region. This, coupled with other national development policy, such as the Guangdong, Hong Kong, Macau Greater Bay Area Initiative and the Belt and Road Initiative, makes Hong Kong truly a place full of opportunities for the business and legal communities. Now, many of you are serving clients that have overseas presence or business dealings with overseas partners and customers. Dispute resolution across jurisdiction is very likely a day-to-day business to a number of you. On this note, enhancement of cross-border cooperation and collaboration between different legal systems, particularly the one in the mainland and in Hong Kong, has been a major priority of DOJ's work in recent years. And in this regard, I would like to take this opportunity to highlight a few initiatives on cross-border matters that may be of particular relevance to you. First, as many of you may already know, Hong Kong has entered into various legal assistance arrangements with the mainland on a couple of matters. Major ones include the following four areas. First, procedural arrangements such as service of judicial documents. Second, reciprocal enforcement and recognition of judgment, what we commonly refer to as the REJ. Third, insolvency matters. And fourth, arbitration. Now, the arrangement for mutual service judicial documents in civil and commercial proceedings between the mainland and Hong Kong court is the first in time among the legal assistance arrangement. To accommodate the increasingly close social and economic ties between the two places, the Department of Justice is, together with the judiciary, actively pursuing discussion with the Supreme People's Court with a view to increasing possible modes of service and enhancing efficiency. We hope that our discussion will result in an improved arrangement which will make service of judicial document between the two places more convenient and efficient. In relation to the REJ, I'm pleased to say that the Mainland Judgment in Civil and Commercial Matters Reciprocal Enforcement Ordinance was enacted in 2022. Compared to the existing regime under the choice of court arrangement, the new mechanism covers a much diverse range of civil and commercial matters, including, for instance, intellectual property rights. And what's more, it covers both money and non-monetary awards. This would establish Hong Kong as the only jurisdiction with just an extensive REJ coverage with the mainland. Another notable improvement the ordinance will bring to the existing regime is that it will remove the requirement of exclusive jurisdiction clause as a precondition for cross-border recognition and enforcement of judgment. The subsidiary legislation under the REJ ordinance is expected to be ready by early next year. With the subsidiary legislation on the Hong Kong side and the judicial interpretation on the mainland in place, the REJ ordinance will then take full effect. Meanwhile, I'm sure that as in-house lawyers, many of you may need to advise your employer on the legal options available when a business partner or a customer has difficulty keeping up with payment or delivery or has simply been driven out of business. If the business partner or customer is based in the mainland, the record of meeting signed by the Department of Justice in May 2021 with the mainland may be of particular interest to you. Under the groundbreaking record of meeting, a pilot scheme is established to allow Hong Kong liquidators and provisional liquidators to apply to mainland courts in 3 cities, namely Shanghai, Xiamen, and Shenzhen, for the recognition of insolvency and debt restructuring proceedings in Hong Kong. This means that assistance may be granted in relation to, for example, the taking over of the debtor's property and investigation into the financial position of the debtor, who is subject to insolvency and similar proceedings. There's no question that this record meeting will provide better protection to safeguard the interests of creditors. And since its inception in mid-2021, there have been a couple of cases where Hong Kong liquidators will recognize and grant assistance in Shenzhen and Shanghai. I'm sure there will be more to come. And given the obvious benefit brought about by the pilot scheme and the fact that the court in both places are becoming increasingly familiar with this type of cases, I sincerely hope that in the near future, it would be expanded to other cities in the mainland. The last is the bundle of arrangement concerning arbitration, which provide a comprehensive regime for recognition and enforcement of arbitral awards between the two jurisdictions. In fact, under one of the arrangement, Hong Kong parties are the first and only one which could be granted interim measures by mainland courts outside the mainland. Further, the legislative amendments and amendment to the arbitration regime in Hong Kong last year, to the arbitration regime in Hong Kong, namely the outcome-related fee structure for arbitration, and secondly, the third-party funding for arbitration. And because of these arrangements, the multi-funding options are now available in Hong Kong for the conduct of arbitral proceedings, and thus will in turn enhance access to justice and improve the competitiveness of Hong Kong's arbitration services. Another highlight which probably has come to the attention of many of you is the implementation of the United Nations Convention on Contracts for the International Sale of Goods since 1st of December last year. The CISG has been described as the most successful substantive uniform commercial law treaty. Applying the convention to a Hong Kong SAR, we allow for a uniform sales law to govern the bulk of Hong Kong's business international sales transactions, enable business to trade with their overseas counterparts on a fair and level playing field by using a sales law which is familiar to the parties. This would further enhance Hong Kong legal infrastructure for international sale of goods and bolster its role as an international hub for trade and dispute resolution. While we endeavor to improve the legal infrastructure of Hong Kong, we know that such legal infrastructure can only be put into best use with complementary administrative measures. An example would be the pilot scheme on facilitation for persons participating in arbitral proceedings in Hong Kong. Now, since the scheme came into effect, arbitrators, expert and factual witnesses, counsel and parties arbitration, no longer need any employment visa. And very recently, this scheme had been extended to include those from the mainland, Macau, and Taiwan, and has been renewed up to February 2025. And with this measure in place, Hong Kong has become a much more attractive and convenient seat for arbitration. If your company seeks to grab the opportunities in the GBA, you may also wish to know more about our initiative, 港資港法 and 港資港仲裁. Under this initiative, Hong Kong invested enterprises are allowed to adopt Hong Kong law and choose Hong Kong as the seat of arbitration in their contracts. This initiative is currently effective in specific trial areas, Qianhai in Shenzhen, and 3 trade zones in the mainland, where exceptional rules apply to allow Hong Kong law or Hong Kong as a seat of arbitration to be chosen, even if these contracts do not have what we call foreign-related elements. Now, this initiative has created more options for Hong Kong invested companies and business enterprises exploring their opportunities. We are actively seeking to further liberalize the measures to cover all 9 mainland cities in the Greater Bay Area. Ladies and gentlemen, as in-house lawyers, you are encouraged to capitalize on Hong Kong's unique advantage, namely a world-renowned common law system with legal infrastructure constantly being improved to facilitate cross-border deals and activities. With the support of the Central People's Government, the DOJ will continue to work hard to explore and take forward initiatives in different areas to facilitate your role not only as in-house connector, but also super connectors, so as to fully grasp the opportunities under the National 14th Five-Year Plan. Last but not the least, my thanks go to Law Society for organizing this very special event and bringing together all these legal talents. I wish you all a very successful, interesting, and fruitful discussion in the conference. Thank you very much again, and I'll see you at lunch. Thank you.
Thank you, SJ, for your very insightful and solution-oriented sharing. As shared by SJ in this keynote speech, China presents huge opportunities for business and legal professionals all over the world. As an in-house lawyer myself, I share the same question with you all as to how best can in-house lawyers help our business to understand this market, and how should we make use of our professional knowledge and connectivity to help our companies to take advantage of national policy development. In the coming panel session, Mr. Lek Chen, elected and serving Hong Kong Deputy of the National People's Congress of the PRC, and Melissa Plan, member of the National Committee of the Chinese People's Political Consultative Conference of the PRC, will share how new national policy development may impact the in-house legal sector. Ms. Joyce Tang, Senior Corporate Lawyer of ANZ Banking Group, will moderate the session. The panelists may take questions from the floor. For those of you who are joining via Zoom, please use Zoom's Q&A function. Panelists will address your questions as they see fit, and you should all now have a QR code together with the conference brochure. We'll be uploading event photos from time to time, and you may access the photos by scanning the QR code. May I now invite Nick, Melissa, and Joyce?
Good morning, ladies and gentlemen. Welcome again to today's 2023 Annual Conference of In-House Lawyers. I'm Joyce Cheng, the moderator of the first session, Impacts of National Development Plans on Business and the In-House Legal Profession. From the opening by Mr. President CM Chan and also the keynote speech from SJ, Mr. Paul Lam, they have alluded to the theme of today's conference, from in-house connector to super connector. So in the traditional sense, it's easy to understand, right? As in-house lawyers, we are the corporate connector. We provide legal advice, we manage the legal risks, and of course, we need to facilitate the business, right, to make the deal, to make the business, to help the business grow. But then now that we can see that there's a trend of increasing population of in-house lawyers, so which means business is actually placing more importance on their in-house legal team. They are more willing to invest in their in-house legal team. That means, actually, as in-house lawyers, are we able to bring in more value to the business development in a more strategic way, in terms of like new opportunities, and in light of the changes in the current climate? So we are very pleased and honored to be able to hear it firsthand from our very distinguished speakers today. And it gives me great pleasure to introduce you to Mr. Nick Chan, MHJP. He's no stranger to many of us. He's a partner at Squire Patton Box. He has computer science background with in-house experience at 2 Fortune 100 technology companies where he had regional responsibilities. Nick is an elected and serving Hong Kong deputy to the National People's Congress of the PRC, in Cantonese, 全國人民代表大會嘅港區代表全國人大. He was also involved in the formulation of the current 14th Five-Year Plan. He's also the director of ELCO, Hong Kong Regional Arbitration Centre, so on and so forth. There's a very long list of his bio, which I will refer you to her booklet. And Ms. Melissa Pang, again, Ms. Melissa, BBS MHJP, and of course, she is also no stranger to many of us. She was the first female president of the Law Society of Hong Kong in its history of 116 years. She is a partner of Pang and Associates. She is also a member of National Committee of the Chinese People's Political Consultative Conference, in Cantonese, 中國人民政治協商會議嘅港區委員，全國政協. She is very devoted to community services. She is the chairperson of the Family Council, the Agency of Volunteer Services, the Hong Kong Press Council, and the Independent Review Committee of Po Leung Kok. Again, a long list, which I will refer you back to the full bio in the booklet. Because if I continue, I think it will take another 5 minutes. So, back to this session. This session will be divided into a few parts. Individual presentation by our speakers, and then there will be a panel discussions, and if time permits, I hope I can open the Q&A session to the floor, to the audience. So, without further ado, let's get started. So, please welcome our first speaker, Mr. Nick Chan. Nick, please.
Good morning, everyone. Okay. Good morning, fellow colleagues, friends, council members, past presidents. Thank you all for the honor and privilege to be here to conduct an exchange with you. I would have to first thank the Law Society for grooming me, to train me, friends, giving me the opportunity to harness my legal knowledge and knowledge about, the general society. And do some civic service, and ultimately currently led to this position, serving fellow citizens, residents as a member of the National People's Congress. So today, in the next 15-20 minutes, I just want to maybe share a few thoughts about how I see our role should be. I've served in-house before, as you've heard. I was at Cisco, I was at AT&T with regional responsibilities. But now I am no longer in-house. I feel like I'm in out-house, so don't laugh at me for that. But anyway, so I think to be successful as a lawyer, at least I'm taught when I was in my trainee days at my first job in Hong Kong, I was told to be a good lawyer, you must understand your client's needs. And another mentor told me to be a good lawyer, you have to help your boss's boss like your boss. So, it applies to us differently. In this context, as in-house lawyers, maybe we have to help our business leaders succeed before their business leaders or before their clients, depends on who that boss is. So I'm thinking, in a general sense, bosses, business people generally would do well if they excel well in a huge market. 1.4 billion people market with over 700 million middle income families. So I think certainly a lot of companies are here, they pay us decently as a regional council because they don't only see the Hong Kong market, but they see the greater China market and the North Asia and the Asia market. We are the southern gateway of China. We are super connector. You are the super connector. I guess one of the thoughts I want to leave you with is, apart from being a lawyer who is able to see the big picture, help clients excel by understanding also the political climate and how things are changing, evolving, technology and all that. It's also think about one day, if you're not ready, take up a business role, make a bigger impact with a legal knowledge, but take on a bigger role, impact more. That's also one of the reasons why I felt extremely satisfying to not just do one case at a time, but to be involved in policy setting, lawmaking. So I would also take this opportunity, hope you could guide me. PRC's constitution, our country's constitution, one country, two systems. We've heard it many times. I know many of us are pushing for this important task, so people to fully understand it. But I would encourage you, when you read the Constitution, to read the preamble, to understand where things are coming from. Also, when we talk about one country, two systems, the two systems, of course, is not common law and civil law. Right? It's the socialist system with Chinese characteristics in mainland China, and the capitalist system we continue to enforce, apply in Hong Kong. So if you look at our Constitution, you look at history, really look at the preamble, it sort of explains why, of the many different paths to democracy we could choose, we choose this system. Our founding fathers, choose this system. So there's not enough time to go into that, philosophy and all that. But if you have questions about it, I'm happy to talk about it offline here. So Article 1 of our Constitution. The socialist system is a fundamental system of the People's Republic of China. Leadership by the Communist Party of China is the defining feature of socialism with Chinese characteristics. It's not something we should, or we would, overturn. This is our Constitution. As lawyers, we know better than anyone. When you operate in a jurisdiction, you must, follow the law. And this is the collective view of the people and, of our people and of our founding fathers, of course. We are now at our fourth Constitution. So I want to say this so I can lead on to the next slide to explain why, Joyce would ask me to say the significance of the 20th CPC National Congress. I'm not a member of the 20th National Congress of the CPC. I'm a member of the next one here, which is the National, next one. I'll come back, but you know what I mean, the National People's Congress. But I would say when I help clients navigate territories, laws, as you do in the region, some of the things you think about is, what are they thinking next? In China, they say, business people say, 食政策. Literally means eat the policy, but I don't think, it's a good translation. It means you maybe ride on policies. So if the big policies are set in March each year, the biggest political calendar of China, where we have the meetings of the CPPCC and the Political Consultation Committee and the National People's Congress, which is the organ, the people, 3,000 odd people who are entrusted to voice the voice of the people. That's in March. But what about in October? In October, if you see the Constitution talks about it's led by the Communist Party, and China does have 9 political parties in play all the time. So there are, of course, differences, of opinion, but it's about how we amalgamate and come to a consensus. So when you see in March, when we vote, you might not see a very tight vote, partly because you had the chance many months to kind of agree on something or disagree and feel that it's not the right time to bring it up for vote. So we have, so I would suggest, as many international news organizations and leaders of multinational corporations already do, look at the October CPC meeting. It's already the 20th session, so every 5 years there's a session. And some of the key things it talked about is to emphasize why one country, two systems is so special, and it's gone into the constitution of the Communist Party of China. So if that's a leading party and their own party's constitution expressly now inserted statements saying, yes, one country, two systems is good, let's do it. And a lot of us talk about, sometimes you might wonder, I get a lot of questions about, well, why is one country, two systems so amazing, so special? Why does it think you could promote peaceful development of the world? So one country, two systems have been talked about in the 1950s. And then in the 70s, in 1979 in particular, where mainland China sent letter to the comrades, friends in Taiwan, saying, let's try this, one country, two systems. And you talk about years, decades of Cold War. And with that backdrop, you see some people in the world are dead set saying, capitalist system is the only system. And there are some who, obviously, countries and people who live in a different system. So if in one country, two systems can coexist peacefully, why can't we all in the world exist peacefully? That's the concept. Anyway, so let me go quickly through the, so I would skim through this slide because a lot of these are then, because it's decided in October, it's sort of, the details are flushed out and then approved in the March meetings at the National People's Congress. Some of the things to highlight would be adhere to the people-centric principle and use technology, tech up. And like, the reason why, over the last 10 years, our GDP has gone, doubled. It's because we have not only short-term plans, but we have medium, long-term plans. And I think as in-house lawyers, we should try to engage in that process within our own company and for ourselves as well. What is our short, medium, long-term plan? So, but let's understand those. So if they have China is a country with GDP of 121 trillion yuan, right? It's a lot of money. So when you put that kind of resource behind ideas, and that's been, sort of from the ground up, built up. So I'm confident they would succeed. Let's talk about what happened in March this year. So in March this year, and typically we would consider the work report of the government. The government will report to the people through us what they've done. And we have the chance to raise questions. And quite frankly, at those meetings, during those sessions and meetings, I am in constant touch with friends in Hong Kong. I'd like to be in touch with you. You could share with me what we can do more. Just like in the 14th Five-Year Plan, when we talk about the 8 centers of Hong Kong, I was actually using WhatsApp up there and texting my friends, bureau chief, can we do this? If we change this word, would you pick it up? Or would you say it's a silly idea? So there's a lot of things going on in the background. The 36 of us deputies from Hong Kong serving at the national level are in touch with different functional constituencies, so to speak. There's no specific seat for lawyers, but of course I feel very much affinity to all of you. So if you or your business through you have suggestions on how we can do better as a country, please let us know. This year we also elected the president for the third term, and we pass laws and make a lot of suggestions. Highlight, I think, it's a modernization of China. A modernization of a country that is second strongest economy in the world with 1.4 billion people. It's going to bring a lot of opportunities. Because of geopolitics, it's a fact, elephant in the room is there, right? It is, from so-called decoupling to now a slight lighter touch, de-risking, doing the same thing, seems like. What do we do? And in your role, where your maybe global headquarters outside of this part of the world says, well, I don't know. You know, look at the Western media, it looks risky, dangerous. Should we just move all to Singapore or elsewhere? Should we shut it all down? Is it really that bad? Is anything else that bad? Anyway, we're counting on you to help share what's happening in reality. There are some clear signs. You see, we're building up a digital economy. At the moment, with a large GDP, but you know, we have about 70% of the economy is digital related. That's about the same as real estate and construction. And maybe 1/3 of the economy is based on import-exports. So if you take all this into account and you can't take into account the change in supply chain issues, you hear about sanctions, AML, frankly, illegal sanctions because they didn't get approval from the Security Council, right, from the UN. And you see some of these import duties that are quite anti-competitive, but they slept on anyway in some other parts of the world. That's going to affect how things are done. I spoke with some people in the logistics industry. They're saying the reality is that there are less shipments going to the Europe and the US. You know, so it's a tough time, but there's a concept of dual circulation. If we could buy from each other, at the moment, you know, Chinese savings about 44% of what we earn. I don't know if we do the same in Hong Kong, but in mainland China, that's the statistics. So if people could spend more on each other locally, and if we could, you know, from 0 to N, if there are technology where we are nothing, we're not there, you know, think about like the Hong Kong, one of the hub that Melissa would mention would be the aviation hub, right? And actually we have to change some words from center to hub, because when it's a hub, HUB, it's there won't be a hub next to you, right? But anyway, but you know, like the Hong Kong airport, anyone from the airport authority here can verify. I think we're using an American software powerhouse. I'm not against Americans, right? But that company also developed, Patriot missiles. So when somebody from the US went over to Taiwan, their stock prices went up. But I'm thinking some of us are worried, well, what if one day all our planes can't take off because the software as a service is just stopped, you know, over the cloud? So what do we do? So there are many opportunities for us to think about how we could help businesses go into these areas from 0 to 1 or 0 to N. At TechHub, there's a lot of concepts about I2X, which is internet, like V2X, vehicle to the network, right? Billy's the expert there. So there's a lot of things to bear in mind. When you think about national security law, don't think about those 4 things. You don't have to think about it all the time. You're not going to breach it, right, people in this room? But think about the 20 areas of concern, like food security, cyber security, biotech security. Those clearly are areas of concern, and a lot of money would pour into it. And how can we support it, and maybe not just a participant but benefit from it at the same time? So I'll speed up. I'm sure Joyce is looking at the time now. The National Data Administration is there because there's a need to level the playing field. There are perhaps in-house lawyers from BATS, right, or some of the big tech firms in mainland China. But it's really about how the whole country as a whole progress in livelihood. Also data sovereignty should belong to you. If you look at the PIPL, Personal Information Protection Law in China, yes, it's as good, if not stronger, slightly than the GDPR in Europe, in the EU. But that's needed because it's a law that, for the first time, make clear data belongs to you, especially in the Web 3.0 world. If you want to go into Web 3.0, you need that kind of law. So don't knock it yet. There are new measures coming up. There will be safe harbors and so on. So in our last meeting, we brought up 200 recommendations. There are some, Chinese theories and concepts. If I have time, I'll go for a bit more. But if you want to excel well in the Chinese political circle, these are things you need to know. But if you're also in business with, national level, areas. These are things, so-called four consciousness, the four consciousnesses, I should say. Think in big picture terms. So today I hope to be a bit of an aid in the area, how to think in bigger picture, taking into account our cultural context and law. Have confidence in the system. Don't just knock it. Think about why it's there. Look at the preamble of the Constitution I mentioned. The affirmations, it isn't so much, when you talk about presidency, whoever is a president at the time, it's who we would be, we should rally behind. So it's not so much personal, individual qualification, so to speak, but we could talk a bit about that. The key is about stability and security in many different areas. Financial, employment, domestic trade, investment, so on and so forth. Very welcoming, for foreign investments. There will be continued liberalization, open up, renminbi, internationalization. We're not going to overtake, personal view, we're not going to overtake the US dollar anytime or have that, intention. But how can we do better, and how can Hong Kong get involved as a financial center in these things? So because of time, I fly through a bit more. Some data, you can look it up online, but generally good. We are globally, we are at a 30-year high on inflation, but in China, inflation is at 2-3%. I believe we should be able to hit our target for 5% growth, but a lot of things we need to do. So here's a, Honto Sixty, a picture speaks 1,000 words, but anyway, because of time. Melissa will also talk more about the Leung Gou, right, later on, the People's Court and the People's Procuratoriate. So anyway, again, I'll pass it to Melissa later on. Belt and Road, a lot of opportunities. It isn't an empty rhetoric. Now, over 140 countries see China, work with China as the largest business partner. So, they would have a need, overseas clients or overseas business people will have a need to better understand how things work. And we need to harmonize some standards, such as rail track sizes have been harmonized so that we can now easier move our products west. And we could also, of course, bypass some submarines somewhere along the seacoast. Modernization is the key, and how we could play a part in that would bring not just opportunities for the people living in mainland China, but elsewhere as well. So a lot of laws need to keep up to date or lead change, or culture. A lot of policy needs to change and improve. Okay, so this slide remind your business leaders overseas if they have doubts. Frankly, my personal admission is we can't do without operating with our friends from all over the world. We are not no man, no person is an island. So we as a country certainly support not just private businesses, but also not just state-owned businesses, but private businesses. And I think you should understand, in a socialist economy, you will always have state-owned enterprises to avoid, so-called the concept or the history of, as you saw, antitrust in the U.S. with railroads being, the purview of rich people operating through trust, and so that kind of concept. So if we speed up, we think about dual circulation, mainland China and Southeast Asian countries. President of the Law Society is going where? Going to Europe and been Asian, been everywhere, I think. So busy people. I thank the Council for his good work. So strong rule of law. It's also our role to assist in strong rule of law. Learn more about digital courts, smart courts in mainland China, and share that with your colleagues if they don't understand it. Hong Kong is the largest offshore renminbi, center, but most of the transactions are still conducted in US dollars around the world. So there's a lot of room to grow, and we don't need to necessarily always be number one in everything. So anyway, plenty of opportunities, plenty of new technologies coming out. Be part of that change, and I thank you for your time. Thank you.
Thank you so much, Nick. Nick can always help us connect with like the big picture, macro view, and connect it to our daily life work, right? So a lot of examples. Thank you again, Nick, because I think as an in-house lawyer, it's also important to understand the more macro national development plan now, so that we can be more forward-looking, plan ahead to assist the business leaders in terms of their business planning and to find out the solutions and to there are doors open up, actually, new doors opening up as well. So how to open that door. So there are a lot of things we can offer. So thank you, Nick, again. In my session, usually I take it very casual. So I will leave it to Melissa to decide whether you want to stand or you want to sit down. I think is a casual chat. I enjoy the dynamic. So next one, Melissa, please. Thank you.
Distinguished guests, ladies and gentlemen, and fellow practitioners. I'm very glad to be here to just have some sharing. As in reply to Joyce's kind words, I'll say I'll prefer to sit, because I can see like Nick is very fit. He can just stand up for half an hour and just keep talking. It's great that you have given such a macroscopic view of the National Development Plan, so we can know more. And actually, I must say, in next slide, there's a lot of big topics that has been covered. And I think it's a great start that if you are interested, and all those topics are very relevant, so you can just check it out on the website. There are many websites that can provide more in-depth discussion. And actually, I must say, like in the two sessions where Nick and I attended, like I think I spent like 8 days there, and I think your time is even longer. So actually, because of the pandemic, we are locked up, we cannot go out. And they actually will give you like stacks and stacks of materials, and there's a lot of reading. And I think it's great. It's like a more in-depth crash course, or to know more about national development plans and about the, how the two sessions. Because I'm a newly elected, I'm newly appointed national member of the CPPCC. That's why I only appointed in February this year. So there's a lot of learning on my part and a lot for me to catch up. But for this in-house council, in-house lawyers annual conference, I think I must congratulate the organizer, the chair, and the organizing committee. This topic is actually very relevant, because a lot of people ask why the two sessions is relevant to us. Even for Westerner, they're looking at it. I think the answer is very simple, because this is the place where they have the annual conference for the National People Congress, as well as the Chinese People Political Consultative Conference. The two sessions, of course, as you would understand, for the National People's Congress, they are China's top legislative body. And for CPPCC, is the National Political Advisory Body. But in the two sessions, there's a lot of things, a lot of learning, a lot of discussion, a lot of deliberation, and also it's in the two sessions we have the election of the leadership for the whole of China. And like for a lot of like foreigners, outside Westerner, they spend a lot of time looking what exactly is happening in the two sessions, because China is the second largest economy, and the two sessions actually map up China's annual economic development plan, look at the growth target, and all those macroeconomic policy. So it's very relevant to all the other countries who has been trading with China, having geopolitical relationship. It's very important. And also in the two sessions, you can see that many significant laws, regulation, and policy actually originated therefrom. And you can look at their issues like environmental protection, from education to healthcare. So there's urban issues to rural issues. They are all raised in the proposals and motions. And it's in the two sessions that consensus are being built up. So actually, they will work out consensus of policy and the next stage will be going into implementation of it. So we can see it's very important for us to know more. For Hong Kong, especially we're part of China, it's very important for us to know more about the direction China is heading and how it impacts Hong Kong. And also because we are lawyers, we've been learning a lot how to look at other people's perspective. We look at, for example, many of us are mediators. You have to look at how one party is looking at the perspective and how is the perspective of the other party. It's very important. Okay, let me mention about what exactly is the CPPCC. Oh, I have to move the slide a bit. Okay, normally just call it 政協, okay? So it's 全國政協. So when you look at it, the CPPCC is actually an organization of Patriotic United Front and an important form of socialist democracy in China's political life. Then people say, oh, it sounds familiar. I know every single word of that in English. But what does it mean? Patriotic United Front. And what's socialist democracy? But when we look at it in more depth, I think it's very important to look at it. Because when you talk about Patriotic United Front, it's actually a political strategy of the Communist Party of China. So they have to do very good network of different groups and keen individuals from different organizations to advance the interests of the party. And when we look at the second word, socialist democracy, of course we know democracy. I mean, for lawyers trained in like common law, we all know about rule of law, democracy, is all the core values. But how do the Chinese, China, the mainland China, how do they understand socialist democracy? This is actually interesting, because to the Westerner, they always say, oh, democracy, it should be at least you have two parties or multi-party system. That's how they look at democracy. But then some will say, if there's only one party, as mentioned by Nick, under the Constitution, is ruled by one party, is that democracy? But when you look at the Chinese way of socialist democracy, it's different, because they are looking at the system is a multi-party cooperation and political consultation under the leadership of the Communist Party of China. Then one would say, how does it work? Multi-party cooperation and political consultation. It's actually very interesting, because as CPPCC member, there's a lot we have to do. There's a role we have to take. We're not just sitting there, rubber stamping. We are not. Let's look at what we have to do. In brief, for a member of the CPPCC, of course, you have the national committee, you also have the province, you have the city, and other layers. You have to conduct investigation and studies. You have to report on social condition and the popular sentiment. And you have to undertake consultation and discussion about matters of key importance. So it ranges from politics, economy, cultural society, and the eco-environment. And also cover other issues of common concern. So it's very important for members of CPPCC to reach out to the people. We are acting as a conduit, as a communication role. We have to hear people's opinion and suggestion, and then to assist the government in addressing concerns, problems, and enhancing unity. So in this aspect, I think you can see that the way that it is structured, there is a lot of participation regarding non-Communist Party people, because they also allow other party, as Nick has mentioned, that in China, there's not only one party, there's 9 recognized political party. So people can take part in deliberation of state affairs and exercise supervision. So when we have deliberation in the 2 sessions, it ranges all different topics. So everyone is like, they have done the research that on a scientific way. So they are reporting on the social issues, economic issues, cultural issues. And they have to do it and submit reports. They have to address the background situation, and they have to put in recommendation. So I think it's a very good way, a very systematic way to address issues so that the, in the 2 sessions, they can have built up consensus, how issues can be addressed. And also when you look at who are the people in the CPPCC, actually, it's a lot of representative. Of course, you have people from the Communist Party, and you also have people from the Democratic parties, and people without party affiliation, and from also mass organization. In China, we have 56 ethnic groups. They all have representation in the CPPCC, and different sectors of society. And also, they have special group from Hong Kong and also Macau and also Taiwan, and also from Return Overseas Chinese, and they have invited different public figures to join. And the National Committee of the CPPCC also as the same term as the NPC. It's a term of 5 years. So actually this year, 2023, is the first year of the term. Then we look at it. One thing, my personal observation is, I'm actually very moved. Actually, you can see, I must say, the mainland, the whole China, has attached a very important significance to Hong Kong. Because from Hong Kong, we think, oh, we only 7.4, 7.5 million people, compared to 1.4 billion, the whole population of China. We are only 0.5% of the Chinese population. However, when we look at the representation in the CPPCC, I'm very surprised. Because you can look at the National Committee, they have 2,172 members. Of course, representing 56 ethnic groups. But the people representing Hong Kong, we have 196. If we look at the percentage, this is quite amazing because we have 9%. 9% of the total number of the National Committee of CPPCC are representative from Hong Kong. And if we just look at the whole Hong Kong population in relation to the Chinese population, we're only 0.5%. One wonders, why? Why so many people from Hong Kong? Because we do have a role to play. We are helping the modernization of the whole China. And I think if you look at it on a historical background, we do. And in Hong Kong, we have like 124 from different sectors, then from the Hong Kong rep. And also we have Hong Kong people in other sectors, for example, in the cultural sector, in the science, in the technology sector, etc. And the next thing I would like to share is a speech. It's part of a speech by President Xi, which he made at the closing of the first session on the 14th National People Congress. He pointed out that it's very important for China to the middle of this century. The central task is to build a socialist, modernized, strong country and to promote the great rejuvenation of the Chinese nation. So they do have the timetable. They do see that like in the middle of this century, maybe like 2030, 2040, they should achieve the aim of modernization of China. And they can see that building a strong country and for this national rejuvenation, Hong Kong have a very special role to play. They will say promotion of a strong country cannot be separated from the long-term prosperity and stability of Hong Kong and Macau. So that's why, like, we can see many national leaders come to Hong Kong to give us a kind of instill confidence in the one country, two system. Because we have to work well, we have a very important role to play in the modernization of China. And President Xi said it's important to promote the practice of one country, two system, and the great cause of national unification. And in the new journey of building a strong country and national rejuvenation, we must promote high-quality development and also adhere to putting people first, actively development democracy throughout the whole process, and implement the development ideology centered on the people. So it is very important that we can see that there's a strong promotion of the practice of one country, two system, and the great cause of national reunification. So this is very important because it's important to look from the perspective of how our national leader is looking at the one country, two system. Next, I'll just concentrate on 3 terms. I think I'll just briefly go over them. I think in the 2 sessions, there's 3 keywords we just have to bear in mind. One is high quality development. So I think President Xi pointed out clearly that high quality development is the primary task of building a socialist modernized country. So when you can see that the importance of high level technological self-reliance is the only way to do so. And also like in the agricultural aspect, building an agricultural power is also very important. So you can see this word high quality development will apply in all different sectors. I think it's important and I think it's very reasonable and justifiable. And the next word is about our own people, 自己人. I mean, without knowing the background, you say, who are our own people? Actually, this phrase is addressed to private enterprise and entrepreneur because the message coming out is like, it's very important for a private enterprise to be a vital force in achieving this Chinese dream of national rejuvenation. So they want to more private enterprise together achieving high quality development. So you can see it's all interrelated. And also the third word that's very important is consolidating the national strategic system. And this is actually regarding building up national strategic system to achieve national strength and a strong military. So they can see it's very important to have a strong military and a national strength. But for these 3 keywords, if you're interested, you can just check it up. It's just repeating in many like articles and very important research. And one thing we also observe is about the Supreme Court's, the Supreme People's Court work report and the Supreme People's Procuratorate work report. You can see the whole China is now focusing on the rule of law. They're building the rule of law in China. And is emphasizing a very firm adherence to the path of socialist rule of law with Chinese characteristic. And you can, one very interesting thing is, if any of you been to the Chinese court physically, you can see in every single court, on top, they have a banner, be it in a metal banner or in a like a cloth banner. They can say it's very important to ensure people are feeling fairness and justice in every single case. So that is the aim. That is like the core value of the People's Court. So that have to ensure whoever going to the court fighting the case, they have to come out and fear, and they can feel they are treated fairly, and they can feel justice is being done. On this aspect, I do have a few observations that's very interesting. The first one is like, you can see like, just as the court system is, they have a lot of cases every year. They handle many, many cases. And also, I think similar to Hong Kong, they do have the issue of judges shortage. And now, in order to make sure justice is delivered without undue delay, so you can see now it's very important they are resolving to non-litigation dispute resolution mechanism, just like Hong Kong is doing, like mediation, arbitration, and now they are, of course, they are talking more on mediation, because as many of those regarding like people enforcing their rights, and also companies. And they have to also done a lot to the prevention of conflicts. And they want to reduce the number of lawsuits. So they are doing a lot of like mediation, dispute resolution. And now they have one-stop service so that they can do it on a more efficient and effective way. And the second one is about smart court. I think and digital court. And you can see like the whole of China, they now like putting a lot of resources. And I think they are definitely leading, because whenever we go to international conferences, you can see the use of AI, digitization of courts, they are all very commonly discussed topic. But in China, for those who have been to the Chinese like court, you can see they are actually very advanced in that aspect. Now they can even have case hearing using their handphone. And also they have round-the-clock litigation service. So people can handle online litigation, court hearing, and other service. And how about the use of AI? Now, lately, I was in Malaysia, and I think there was news. They say Sabah, in the eastern coast of Malaysia, they claim they're the first court to use AI, because they use AI to deliver judgment in the aspect of, I think, it's personal injury, and also in some traffic offense cases. But in China, there's a strong application of using artificial intelligence. They have also developed like 5 principles about how to use AI. However, I remember following Law Society to visit the Supreme Court. I did raise the question like, oh, how does the use of artificial intelligence in the judiciary? The answer I got back is they do have principles how to use it. However, the judges must have the final say. So there's no worry. You rely on the AI to do it, to do all the background, to do the suggested recommendation. However, the judges do have the final call, the final say on that. And another aspect is regarding judicial cooperation. In the report, which we learned in the 2 sessions, you can see regarding cases that are related to Hong Kong, Macau, and Taiwan. Actually, every year, the Supreme People's Court handle over 46,000 judicial assistance cases. And I'm very glad to hear from the SJ from the opening speech regarding judicial assistance, reciprocal enforcement on judgment, and also insolvency, and also the arbitration, interim measure, etc. So it's a very good way, because we can see Hong Kong government through, and of course the DOJ has been doing a lot for the infrastructure for the Hong Kong legal community. So that's why we can have the advantage of acting as an international super connector. But from when we look at it from the whole of China, looking at the report from the Supreme Court, you can see the way they look at it. The use of AI, and also the judicial cooperation, like also like dealing with Hong Kong, Macau, and Taiwan. It's all very important. And any of you, if you're interested, go and look at the report. It's actually quite thick. But I think they do have the English version as well as the Chinese one on the official website. The next, I'm just going to be quickly addressing on the 5 years plan. Of course, in the 5 years plan, we can see that it's mapping out the development plan and action agenda. And actually, for Hong Kong, we have a chapter on the Hong Kong aspect. And the Hong Kong chapter, we have been in the 5 year plan since the 11th, I think it's 2006. And we can see that it's very good that there's a chapter outlining the support of the development of Hong Kong. And they also have strategy to enhance Hong Kong competitiveness in all round different economic activity. And also because how to help Hong Kong integrate in the development of the whole China is a very big issue. And we can also, why this is the 14th 5 year plan is so important. Because actually, when we talk about 小康社會, building a moderately prosperous society, that has been achieved in the year 2020. And now from 2021 onwards, which is the start of the 14th 5 year plan, which is another start. This start they call a new journey, 新征程. So it's towards building a modernist, socialist country. I think when we look at all those reports, the 14th 5 year plan, etc., at least we see a very clear map of what the whole China is going towards and what is the role of Hong Kong. So that's why if we have a role in part of the whole modernization of China, if we know what are the roles given to Hong Kong, different roles, at least we can equip ourselves to seize the opportunity and to meet the challenges. I think on the 14th 5 year plan, there's a lot of main content. I think you can just take note of it. And just if you're interested, go and check it out. But I think if I just summarize quickly on the Hong Kong chapter, there's two important points. First, it goes back to the constitutional order. It's attached very important on the one country, two system. The constitutional order will be maintained, but at the same time, we have to acknowledge the central authority over jurisdiction over Hong Kong. So we go back to the basics. So that's the number one. Make sure the constitutional order of Hong Kong is maintained. And also about national security, sovereignty, security, and development. So they're all those going back to interrelated. But it's very important. Those are the core points, which we hear from day in, day out. And the second point is how to, that's a more practical, the second point, how to enforce, reinforce, and enhance Hong Kong competitive advantages so that we can integrate in the overall development of Hong Kong, of the China. Because that's no good if the whole China go through their modernization. And if we are not proactive, we could be left behind. Because we can see it's a lot of competition, even from other cities, other provinces. But there is a special role for us to play, and it's important for us to effectively discharging our role. And one very important point is in the 14th 5 year plan, we all know, we've all been aware, and Hong Kong Law Society has been putting a lot of effort. It's about the Greater Bay Area. And I think we do have our Greater China Chairman, Roden, our VP here. And also our President, CM Chan, has been leading a lot of delegation in the past year or so, and also in coming months, to visit different cities in the Greater Bay. And I think for Hong Kong Law Society, we have regular meeting with law association in the Greater Bay, so that we know what we are doing, how we can work together to collaborate. And I think it's important for the Greater Bay different law societies and also their people to know what Hong Kong can offer. So it's important. We are good, we are very strong in different areas. But do they know? Some of them might know. But this Hong Kong story is important for us to tell the Hong Kong story well, and also tell the story about the strength of the Hong Kong legal profession. Regarding the 8 centers, I think there's no need for me to go through it each one by one. I think all of you would be very familiar with the 8 centers, which is the 8 role that Hong Kong got the strength. And especially relevant to Hong Kong legal profession is we are the International Legal and Dispute Resolution Service Center. And of course, the Intellectual Property Trading Center. But when you look at the 8 centers, one thing in common, if we're looking from the perspective of a legal profession, all of them require legal backings. They all require legal service. So that's why we don't just concentrate on the one that's related International Legal and Dispute Resolution Center, because financial center, innovation technology, cultural, trade, shipping, aviation, etc., they all need people with legal background to assist. I think on this point, maybe I can stop. Thank you.
Thank you very Thank you very much, Melissa. I think Melissa has shared a lot in terms of the role of CPPCC. It gives us a lot of transparency as to what how things are done at the CPPCC level. I think it's very interesting to hear about the court report. So I think it actually feels quite different to hear it directly from Melissa rather than just read it from the newspaper. So thank you again. So let's move on to the panel, a quick, short and sweet panel discussion. So first question to Nick. In your presentation, you've been talking about how the macro national development plan would have an impact on the business. So in light of the current geopolitical scenarios, so how would you advise any views as to how business can safely navigate through such situations?
Thank you, Joyce. I would say have confidence in the long-term prospect of this great country. And therefore, when you help your customers, your clients, your boss's boss, or your boss set up, rearrange supply chain, do better management, AML, all that. Don't just all completely move out. There are many good reasons to be based in Hong Kong, right? Geographical, tax, all that. So I think in short, I would say help them understand the big picture, share your cultural in-depth knowledge for someone living on the ground here, and let them together with you join the board and make the right decision. Thank you.
Thank you, Nick. Moving to Melissa. So I think there's one buzzword that every one of us has been talking about, GBA. I think you also lightly mentioned it in your presentation. So Greater Bay Area, Hong Kong is part of the Greater Bay Area. And then there is also the GBA lawyers exam. So I'm not sure how many in-house lawyers have taken it, but I'm sure it seems like it's a discussion there about any opportunities for business in the GBA. What do you think? And also in particular from the legal profession perspective, what do you think about the role and opportunity in GBA?
No, I think the role of opportunities, whenever you talk about lawyers, we follow our clients. And or in-house, of course, you follow your own boss. I think if there's a lot of development, a lot of opportunities in the GBA. So for corporate, for individual, and you can say a lot of people actually move to the GBA to work, to start their business and also to study. So I think it's important for lawyers to follow their clients, simple as that. So there's a lot of opportunity, be it in different industry. And you can see that for the GBA, the population is over 18 million. You can see Hong Kong is only 7 million. When you look at the ratio of lawyers, you all know that Hong Kong have like 13,000 solicitors, okay, not counting the barristers, okay? For that, you look at the ratio, it's like every 500 people, that's one lawyer. This ratio is actually, on an international level, is actually quite high, okay? So in order for like I do have members coming to talk to me and say, wow, if we don't make the pie bigger, then how can we get a good earning, especially when nowadays the economy is a bit soft. So I think it's very important for the GBA is so close to us. 1 hour living, okay, I think it's 1 hour you can get to most places in the GBA. And there are opportunities both for lawyers and also for our clients. It's important for us to take a step there. And I think for the GBA exam, I think the pilot scheme, we have the first one in 21, the second one 22, and the third one just a couple of, like a month or so ago. I heard the number of solicitors taking part or lawyers taking part is 1,500. And up to now, because I think the first or second batch, they already can to get registered, get their license, practicing license. And I think the number is now around like 300 plus. And I think it's a very good opportunity for us to get another qualification. It's just like many of us are qualified in like UK, in Australia, and also in like maybe some taking New York Bar, etc. I think it's very important. So it is a pilot scheme, and I hope soon they'll make it into a permanent scheme. Law Society have done a lot trying to convince the MOJ that it's a very worthwhile exam. And actually, for those who say, I'm in-house, I will not practice in the GBA, but why should I take this exam? I tell you why. If you just go through newspaper and just go article, you're not doing the learning in the quickest way and the most effective, systematic way. For those who have, I think here, a number of you, maybe I just head count. How many of you have taken the GBA exam? Okay, I do see a couple. It's a very tough exam. And I remember looking at the material. I say, goodness, I don't count it in inches. I count it in feet. 2 feet tall. Oh, that's really scary. However, after going through the information, you do learn a lot. And it's the most quickest way to learn. And I think even for those you don't think you'll practice, those information are very important. Just like what the information Nick and I just share. I think it will be useful to at least to know more about those things as a background. Because you can see even many non-Hong Kong people, Westerner, foreigners, they are studying those. They are learning that.
Yeah. Thank you, Melissa, because I think taking the GBA exam really helps to understand the legal system and the laws and the relevant sort of mindset, the legal mindset of China. So even if as in-house lawyers, whether or not you're going to practice as a GBA lawyer, but it's worthwhile to understand the law and the legal system so that it will assist you to have a better understanding, to have a better communication to help your business, to do business in China. So there won't be that kind of like gap when you have to communicate with your external counsel, so on and so forth. So I believe it's a worthwhile study. Moving back to Nick. So I think in Melissa's slide about the 8 centers, so they're like all different industries. And actually as in-house lawyers, I'm pretty sure we have in-house counsels actually in all those different industries. But then in talking about all these like national development plans, etc., do you see any opportunities for in-house lawyers? And we are talking about we being the super connectors. Any insights?
Thank you, Joyce. I'd say as in-house lawyers who are in the thick of everything, you see a lot of things behind the scene that maybe lawmakers don't see because you are at the front line. So in many ways, firstly, there are not just 8 centers for Hong Kong. These are 8 focus areas, right? So to the extent you can see other areas worth developing or how we could develop it better, please raise it to make the pie bigger or make the cake bigger in China, I would say, for one. Secondly, I'd say we should firstly maintain our strong mental health despite taking those exams. Mental health is important, physical health is important, and then we skill up with all the technical knowledge and geographical knowledge. As you practice regional law, we're probably not licensed in every place we have understanding or have responsibility for, but learn just not the law, but in some ways the politics of it. I mean, there's election in Taiwan in January 2024. There's election in the US, for example, in November 2024, but the candidates have been announced since March this year. So a lot of things are happening behind the scene that make things the way they are now. But if you could see behind the cloud, blow it away and see, there are things we could do. And I would encourage you, as I said at the start of my presentation, to take on also business roles and maybe other public service role as well.
Thank you, Nick. I still remember in last year's conference, we also talked about, whether internal legal could take a seat in the board. So I think this is the opportunity where, as the in-house legal counsel, actually we can also take a bigger role in the business. So thank you once again. I've got a queue from I have to wrap up. So thank you once again to Nick and Melissa. I think I'm sure, if I may, I'm sure they will be more than happy to interact with any one of you. If you've got any comments, any questions, please feel free to reach out to Nick and Melissa directly. I'm sure they will be more than happy to do so. So once again, thank you, Nick and Melissa, and I will end this session now. Thank you.
Thank you, Melissa and Joyce. May I invite you to stay on the stage as the Law Society would like you to present you a souvenir. May I invite Vice President Mr. Rodentong to proceed to the stage and present the souvenirs to our panelists. Thank you, Roden. And thank you once again, our panelists. Just a gentle reminder that we'll be uploading the conference photos from time to time. You may access the photos via the QR code. We'll now take a short break before we move on. Light refreshments are served in the foyer and room S222. Please help yourself. Our next panel discussion will start at 11 a.m. Please stay tuned. We have invited a panel of legal professionals from a diverse background to discuss how in-house lawyers can make use of different dispute resolution options to help our companies to resolve cross-border disputes. These include Mr. P.S. Howe, Partner, Charles G. and Kenneth Sid, Mr. Billy Ng, Director, LegalMap Limited, Dr. Thomas So, Chairman, eBram International Online Dispute Resolution Center Limited, and our moderator, Ms. Irina Chen, Vice President, KKR Asia Limited. Please join me in welcoming our panelists to the stage.
Hi, everyone. Thank you for coming to this session today about the topic is when there are no borders, dispute resolution across jurisdictions. Now, to my immediate left, we have Dr. Thomas So, who's as everyone knows, as the past president of the Law Society of Hong Kong, and he's also the chairman of eBram International Online Dispute Resolution Center Limited. And to his left, we have Mr. P.S. Howe, who is a partner at Charles Chu and Kenneth Sitz. And to his left, we have Mr. Billy Ng, who's the director of LegalMap Limited. Today's topic feels like a pretty broad topic, with a lot of potential issues and perhaps questions from the audience. But perhaps I'll start with the eBram International Online Dispute Resolution Center Limited. Now, for us in-house lawyers who may or may not have exposure to disputes or dispute risk management, this seems like a very, very innovative way to deal with disputes, or as I have learned from the website, the official website of EBRAM, actually there's a range of services, including mediation, some non-sort of litigation type dispute resolution services. So I would like to invite Dr. So to actually introduce and share with us what the EBRAM platform is about and how it's what prompted him to start this very innovative legal tech service.
Thank you. Thank you. Can I go over there? Thank you, Irina. Good morning, ladies and gentlemen. Thank you to the Law Society for organizing this event, which I have actually attended continuously over the years. And this time, thank you for giving me the opportunity to talk about EBRAM. Many of you probably may or may not know, EBRAM, in fact, is one of, if you can use that term, subsidiary of the Law Society of Hong Kong, because Law Society of Hong Kong is one of the founding members of EBRAM, and Law Society has been very supportive to EBRAM's work, and hence today, this year, particularly because all the products that EBRAM have spent time to develop have started to roll out. So we see today as a very good opportunity for EBRAM to introduce to all of you what we can offer to you all. Now, although the name of EBRAM suggested that we are focusing primarily on online dispute resolution, but in fact, it is not just that. EBRAM is a law tech company, and we focus on all type of use of technology service to promote and take legal services and dispute resolution services to the next level. I have a set of PowerPoint that I will take you through. And by the end of the session, if you have time, we have a booth outside where you can take time to try out some of our platform and some of our product and try it out for yourself. Because being members of the Law Society, in fact, we are relatives. So, we can now move to the second slide. Well, the need for effective avenues for making business, not just resolving disputes, as well as resolving disputes that may arise with robust and trustworthy resolution mechanism, has never been more critical before. So we think that the avenue that we can choose to do all this, doing business and resolving dispute, can be done online. As part of today's session, I will provide some background on EBRAM, our milestone thus far, and our service and our offerings. As I introduced just now, with the support of the Law Society of Hong Kong, and also the Department of Justice, and the Hong Kong Bar Association, as well as the Asian Academy of International Law, EBRAM was founded as an independent and non-governmental, non-profit-making organization, providing services as an online deal-making and dispute resolution institute. The motivation for establishing this institute was primarily to promote the use of technology in deal-making and in alternative dispute resolution to improve access to justice. So, because we are non-profit making, the fee that we generated do not go into my pocket, for example, or the Law Society's pocket, but it will be put into use into EBRAM's funding for the purpose of pushing further down the line the provision and development of technology to assist legal services and dispute resolution services. So to achieve this, EBRAM was set up to be part of an ODR, Online Dispute Resolution Institute, and part law tech startup with its own technology development capabilities. This atypical combination places
EBRAM uniquely in the law tech and dispute resolution community and perfectly in a time of rapid digital expansion. EBRAM was established in 2018. In the past 2.5 years, EBRAM has developed 4 ODR platforms and the Hong Kong Legal Cloud. We will also soon be launching a deal-making portal, which will be primarily for businesses and their transactional lawyers like yourself. So before I talk about ODR, I would like to touch upon the deal-making portal first. The deal-making platform is an all-inclusive e-commerce portal that facilitates cross-border transactions using advanced technologies to help you identify and collaborate with potential business partners. Of course, doing business online is not a new thing, and businesses, in fact, have been conducted one way or the other online. And this has happened for the past 25 years. But be that as it may, there is still very much to be desired and improved in doing business or resolving disputes online in a well-structured manner. And indeed, the speed of doing business online has only grown more haphazard. Hence, we think that with the deal-making portal, we can make doing business online a safer, more certain environment, which will benefit, in particular, cross-border trade for particularly SME and MSME. The deal-making platform has a number of features. It has an e-directory system, and it also includes deal flow management. The deal flow management helps businesses track deal progress, create meetings, upload and download documents for business negotiation and e-signing. Our deal flow management system also helps users monitor the progress of a deal with indicators. Users can directly negotiate with their deals online through the video conferencing system. User verification and credibility check is also an important feature of this deal-making portal. As part of this, the deal-making portal facilitates applications for LEI, that is, Legal Entity Identifier, a global unique identification for legal entities, enabling other users to help identify entities and increase traceability and security in transactions. It allows individuals or businesses to determine if they are dealing with recognized business entities. This eKYC function during registration for the deal-making portal also provides a second layer of verification as to the identity of the business entity. As I mentioned before, the deal-making platform will help with cross-border trading, and cross-border trading has definitely been conducted at never before seen volumes, thanks to the internet. But because of the overload, it is more often than not in the case of cross-border trade that dispute resolution mechanisms become much more an afterthought. Yet, cross-border disputes can arise in various contexts, from commercial, technology, and IP in international trade. And indeed, many cross-border disputes do arise, but the parties find that there is not much they can do about it. When these disputes do arise, more often than not, the businesses involved find themselves in a mess of legal issues, including much uncertainty as to where to even begin seeking claims against the counterparty, and much hassle over figuring out which laws would apply and be useful. EBRAM serves as a groundbreaking solution to bridge the gap between parties to provide an accessible and efficient and a cost-effective resolution. Leveraging on technology, we have therefore developed online dispute resolution, ODR, platforms, and where appropriate, we have applied the latest technologies such as blockchain and AI to the platform to facilitate the resolution of disputes. This allows EBRAM's ODR system to be swift, affordable, and convenient. It is noteworthy that EBRAM is one of 7 qualified institutions in Hong Kong eligible to apply to mainland Chinese courts for interim measures in aid of Hong Kong-seated arbitral proceedings under the arrangement concerning mutual assistance in court, ordered interim measures in aid of arbitral proceedings by the courts of the mainland, of the mainland and of the Hong Kong Special Administrative Region, where claims made on behalf of clients involve the need to secure assets in the mainland, and EBRAM administered Hong Kong-seated arbitration could be a potential avenue for achieving this objective. There were a number of objectives when designing the ODR system. It was meant to be a set of tools for arbitration and mediation proceedings that were secured by design and had bank-grade encryption capabilities enabled. The encryption and secure designs are intended to satisfy the confidentiality requirements under law for arbitration and mediation proceedings. One of the key advantages of EBRAM's ODR platform is accessibility. Making the system convenient and affordable is key to improving accessibility. Parties involved in the dispute can access the platform from anywhere in the world, eliminating the need for costly travel and enabling individuals and businesses to resolve their conflicts in a timely and cost-effective manner. It is, of course, not sufficient for the ODR platform to exist alone without legal backing and without institutional support. That is why the ODR platform is based on a range of dispute resolution mechanisms, including negotiation, mediation, arbitration, the last two of which operate within the same framework under the Mediation Ordinance and the Arbitration Ordinance in Hong Kong. These methods provide parties with flexibility and control over the outcome of their disputes, allowing for tailored solutions that meet their specific needs. EBRAM's role as an institution ensures that the rules and procedures to support mediation and arbitration are complementary to the ODR platform. In this regard, EBRAM has 4 sets of rules to cover different usage scenarios. So why use EBRAM's rules? EBRAM's ODR platform does not require the use of EBRAM rules. However, parties in dispute enjoy advantages when they agree to use EBRAM rules alongside EBRAM's ODR platform. Administrative fees of EBRAM under EBRAM rules are generally more economical compared with many other institutions. Moreover, the vast majority, and in some cases all, of the cost of using the ODR platform is included already in the administration fee. In addition, EBRAM is listed as one of 4 ODR providers under the APAC Collaborative Framework for Online Dispute Resolution of Cross-Border Business-to-Business Disputes. Indeed, it is the first and only such ODR provider from Hong Kong. Pursuant to the model procedural rules under the APAC Collaborative Framework, EBRAM launched its EBRAM APAC rules, showcasing its determination in providing a fast and affordable resort to resolving commercial disputes among the APAC economies, in particular for the MSMEs. If you are interested in using the EBRAM rules, it would be a good idea to insert a dispute resolution clause into parties' contracts in advance, which specifies using our rules and our institution for administration. Here on the screen, there is a QR code to our web page, which sets out our model clauses for the dispute resolution clauses, if you're interested. Here, let's look at the ODR platform. ODR is not about replacing mediators or arbitrators with technology like artificial intelligence or automated prompting. We distinguish ODR from automated decision-making because, as fast-growing as artificial intelligence technologies are at the moment, we are conscious that there is still some way to go before artificial intelligence technology is mature enough to make automated decisions, or would be flexible and intelligent enough to conduct mediation on its own. Indeed, EBRAM currently incorporates aspects of artificial intelligence, specifically machine learning translation, to make it easier for parties with different language backgrounds to communicate. Indeed, ODR is about helping parties to manage their disputes with an end-to-end toolkit of technologies. The idea of ODR is to move the entire process from commencing an arbitration or mediation to the settlement of the disputes online. There are multiple compelling reasons for doing so. Parties can share relevant information and documents to the arbitrator or mediator and the counterparty. The advantage of using the document sharing and case file management function of the ODR platform over transferring the information by email is that email sizes with large attachments can often be restrictive. Even if your email server is capable of sending larger email attachments, there is also a real risk that the email recipient's inbox may not accept large attachments, resulting in bounce-back emails and failed transmissions. The document exchange feature on the ODR platform avoids this by providing large amount of storage space for parties and the mediator to utilize. Emails also take time to manage, no matter whether you are a lawyer who has to handle multiple cases simultaneously, or if you are a business person whose email relating to your dispute would very likely get mixed up with other emails. It can be cumbersome and time-consuming to isolate the emails, documents, and information relating to the matter. However, if the parties utilize the documents exchange and sharing function of EBRAM's ODR platform, the information will already be in one place, right from the beginning. Parties will also be able to very quickly see consolidated information about their case. In the past, lawyers may have to craft their own information sheets about their case, but with the ODR platform, it is now all laid out clearly. This includes information relating to the parties, the specifics of the arbitration in question, list and calendar views of the procedural timetable. EBRAM's ODR platform also integrates video conferencing directly onto the platform, so it would not be necessary for the parties to make extra logistical arrangements. Moreover, the video conferencing capability was designed specifically to complement the ODR platform. So security of the platform has been of top priority, which contrasts with commercial video conferencing software offered for general use. The platform includes real-time machine transcription and translation capabilities. Let's now take a look at the machine transcription feature.
My name is Mei Tai, and I have been appointed by EBRAM to serve as a neutral arbitrator to hear and decide this matter. I, not EBRAM, will decide the award. Could the parties or their representatives please introduce themselves?
Yes, thank you. My name is Robert Roeder, and I represent the claimant in these proceedings.
And my name is Freeman Yo, and I represent the respondent.
I think the print is a bit too small, so if you're interested, you can try it out again at the booth outside when you have time. So about e-signing, if the mediation or arbitration is successful, it is necessary to draft and sign the settlement agreement as soon as possible to secure the new consensus. With the integrated electronic signing feature, the mediator and the parties can swiftly upload a settlement agreement onto the platform to be signed, even if the parties remain in remote locations. The e-signing can be done on any computing device with an internet connection. And if the parties wish to have a more intuitive signing experience, they can also sign on their mobile phone by scanning a dedicated QR code. One point about eBRAM's e-signature service is that eBRAM's e-signatures do not just allow you to conveniently sign on whichever device you may have, but more importantly, and behind the scenes, the system also generates a unique marker of your document that is then stored on a blockchain, which we host. Once that is created and stored on the blockchain, the document cannot be tampered with. Our system helps the parties verify the integrity and keep an audit trail of signed documents. This is something that traditional wet ink signatures or even digital images of signatures passed on documents cannot do. I encourage you to explore eBRAM further to experience its benefits firsthand at our booth in the foyer outside. Then let's talk about Legal Cloud. Hong Kong Legal Cloud is another service alongside our ODR platform that provides the ability to store and exchange documents securely online. To conduct legal research with our partnership with LexisNexis and to conduct quick machine translation of documents through our partnership with RWS. This toolkit was developed to aid lawyers in their day-to-day work, especially lawyers from small and medium-sized law firms and barristers who may historically have more difficulty accessing to the latest law tech. With a subsidy from the Department of Justice, we have been able to provide this service for free and will continue to be free for the next year or so for the Hong Kong legal community. So for those who have not yet registered, please do so after this session. All of these platforms are secured by design because as a legal institution itself, eBRAM appreciates the importance of confidentiality. And in terms of data privacy, eBRAM complies with not just one, but 3 sets of data laws, namely the Personal Data Privacy Ordinance in Hong Kong, the Personal Information Protection Law in the mainland, and also the General Data Protection Regulation from the EU. You can see that we are very serious about ensuring data privacy. Data itself is also secured using bank-grade encryption, and we have put our system to test by external security consultants who have conducted penetration tests and security audits, and we do that very regularly every year. eBRAM represents a significant leap forward in the field of dispute resolution and in deal making in the digital age. Its accessibility, security, user-friendliness makes it an indispensable tool for businesses and lawyers worldwide. By embracing this innovative platform, we can navigate the complexities of the modern business landscape with ease and confidence. I urge you all to embrace this new approach and consider adopting our deal-making platform, ODR platform, and our law tech for any future needs. Thank you for listening, and me and my colleagues from eBRAM are here to answer any questions that you may have after this session. Thank you.
Thank you so much, Dr. So. That was incredibly interesting and impressive, because it really rewrote my impression that dispute resolution is the traditional litigation with lots and lots of bundles. And when I watched the demonstration of machine learning translation, that was incredibly fascinating. I mean, in the past, we would have to engage someone, a professional translator, to sit in and live translate everything. And that certainly, this platform and this technology certainly saves a lot of costs and makes dispute resolution a lot more time as well as cost efficient for the parties. So I actually have one question for Dr. So, if you don't mind sharing with us. In building something so innovative for such a traditional sector of the industry, dispute resolution, what was the perhaps top of the mind challenge that you have encountered in leading this effort?
Thank you, Irina. This is a very good question. And again, I would like to say thank you to the Law Society because obviously, and also people like Nick Chan, I mean, who has been instrumental in helping eBRAM to grow from its birth, right? And it is not easy, okay? And I'm looking at it, and I'm always using this example to share with people, encouraging people to use technology, meaning you are asking people to change how they do things, okay, traditionally. I was in fact, in an arbitration last week as an arbitrator, and lawyers and barristers were still flipping through their bundles, and I was suggesting, oh, don't you're exactly right. They were using consecutive translator, and so we had to sit there and wait for the translation to finish, then the cross-examination continue. And I was asking them, do you not know that, you know, about eBRAM's product? And they say, what is eBRAM? So our thought, you know, that is the reason why we need to introduce this more to all of you. Now, the example that I was saying is many of you probably were not born the age that I was born, right? Okay. In the 80s, I still remember at the end of every month, we were eager to check on how much we get paid. Okay, so on the 28th of every month, I remember there would be queues at the counter of big banks in Central, because we used to have this book, red booklet, okay, where you go and kind of clock in. We call it 打保, okay, to check on the salary, how much you get every month. And there's queues, long queues. And you still have to do every transaction you want to get cash off counter. That's a big queue. Okay. Then there is a creation of this ATM machine, if you remember, the ATM machine. And at first, people feel, oh, you know, is that real? You know, you go to the machine, you click in, and then money transfer. But then, you know, in the old days, you feel like getting something more tangible. You know, you have a bank slip confirming the transaction. So that is something real, tangible. And it takes time for people to change the way how they do things. And the ATM machine then changed from a cash point into a machine that you can actually do transaction. Okay. And now, 40 years, not that many people use ATM machine anymore because you can now do everything online. So it takes time for people to change the mindset and the way how to do things. And how do we encourage that? I think, first, I think the product really need to be user-friendly and let the users know and experience that this is something even better than how they have been doing things. That is first. And second, I think we need policy from the government to help us push this. Plus, users like Law Society, Bar Association members give us a chance, use our product, feedback to us, let us hear what you think about the product, and we improve. I think that is, at the moment, what we are doing. And over the past 2.5 years, we have received a lot of support, a lot of input from members, from users, that we really treasure, and we hope that we can have all of you, okay, try on our eBRAM products, because I just introduced you, it's free, okay, for members, and let us know how you feel, whether there is anything that you think we should do better, because you guys are the users. You know, sometimes we have to listen to you, because, as I said, a product will not be successful if it is not user-friendly. So we will listen to you, and we will improve our product and our services to meet your expectation. And that is, at the moment, if you ask me, you know, the challenge of eBRAM. And I would hope that people around this room will use our product and support our direction in trying to introduce more technology service and technology product to help legal services and also dispute resolution services to excel.
I completely agree. I mean, I, for one, would be very keen to try that product. It looks like a very helpful product for in-house counsels, in particular in managing, the litigation or dispute resolution process and costs. So thank you again, Dr. So, for your sharing today on eBram. So as we all might appreciate, of course, when the problem arises, it's very important to fix it with the right method. But as in-house lawyers, we may always be more interested in the stage before the problem actually arises. We'd like to prevent it, we'd like to manage the risk. So I know that PS today has something to share about how to effectively prevent or manage the risk of dispute resolution. So may I please invite PS to share with us. Thank you.
Good morning, fellow professionals. First of all, I wish to thank the Law Society of Hong Kong in organizing this event, as well as our sponsor to make this event happen. I also want to extend my thanks to Dr. So in his excellent presentation of the eBram platform. I must confess, Dr. So, that I'm still an ATM user, as well as a court user, which bring a lot of hard copy bundle to the court. In fact, I'm a big client of a moving company. Not that we need to move office, but from time to time we need to move hundreds of boxes of papers to the court for the hearings. So I only hope that one day the eBram technology can be extended to court users. In fact, thanks to your relentless efforts, as well as those, including Nick Chan, in promoting the eBram platform, I've seen an increasing trend of companies, including tech companies who are familiar with the eBram technology, to include in the dispute resolution course for eBram arbitration rules to be incorporated. For this topic about dispute resolution, even though I myself am a dispute resolution lawyer, my first and foremost advice to every client is please prevent dispute risk if possible, or otherwise manage it. Dispute is not only costly. The most significant downside of engaging in dispute is that it is time-consuming and counterproductive to the client's usual business. Much time would have to be spent by the client, as well as the in-house counsel and the legal team, in retrieval of historical records, giving very detailed instructions to your lawyers, and also to rebut the other side evidence and case. So much time would have to be spent in locating relevant documents out of tens of thousands of emails and documents to rebut one point. And these times could otherwise have been spent for more productive business. And that's why my first and foremost advice to each client is please prevent litigation or disputes at all costs first. In terms of dispute risk prevention, one of the most important stage would undoubtedly be at the contract negotiation stage. Many of us, as lawyers and in-house counsel, would be familiar with the allocation of risk in contractual contexts, such as limitation of liability, warranties, how wide or how restricted warranties should be given, and all sorts of security given in ensuring the performance of contract. For instance, there might be guarantees, there might be share charge in the underlying project companies. There could be insurance bond or irrevocable power of attorney for the enforcement process to happen in case of default. Many parties would design appropriate corporate structure to align their commercial objectives in ring-fencing the dispute risk or to facilitate enforcement process. I must also stress the importance of conducting effective due diligence of the target company as well as the counterparty in understanding the risks involved prior to the conclusion of contract. In cross-border context, it is also important to engage local counsel and sometimes specialist counsel to advise on the contract before conclusion. But it is, however, very easy to say all this than it being done. The main reason I've always encountered is that at contract negotiation stage, all the parties are in good, usually, but not always, in good commercial terms. And for the sake of speedy conclusion of the deal, they might be willing to agree to terms which are not clearly defined in accordance with their intention. This is in particular in the context of ongoing obligations after the conclusion of a contract. For example, ongoing obligation in a business venture, and sometimes the terms are not clearly defined by reference to specific benchmark. Some of the reason is probably due to the need for a speedy conclusion of the deal, and other reason could be at the time of the conclusion of the contract, there might not be sufficient knowledge and time to designate the benchmark performance. In that case, and usually the client might say, okay, don't worry, we will manage, we negotiate when it comes to it, and the parties are very friendly, we don't have disputes. But in reality, disputes will easily arise when the relationship turns sour. And when that happens, the arbitrators and the courts who adjudicate the case many years after the conclusion of the contract, they can only interpret the contractual clause in accordance with the usual contractual principle, which might not be the intention of one party at a time. In cross-border context, the parties may understand the contract terms from their own domestic context, and the difference in the understanding can lead to disputes. So one takeaway from this is try the best to define clearly the contractual terms. Unless there is no choice, try to define specific benchmark as to ongoing obligations. This will effectively prevent and manage the litigation risk. In anticipation of the reality that dispute may arise, parties should pay special attention to the choice of law course and dispute resolution course, which is critical in managing the litigation risk. Unfavorable choice of law or jurisdiction can adversely impact a party ability to seek legal recourse. For example, if you are a minority in a joint venture, you may wish to go for a jurisdiction which provides for remedies such as unfair prejudice or derivative action. Hong Kong law is one of those jurisdictions which provides this remedy. And one thing to bear in mind in selecting choice of law is the consistency between the governing law and the jurisdiction clause. For example, if a dispute is to be resolved in Hong Kong, generally speaking, it would be sensible to choose Hong Kong laws unless there is good reason not to do so. Inconsistent governing law and jurisdiction clause can increase the time and cost of a dispute due to the need to present expert evidence in foreign laws. In terms of dispute resolution clause, the obvious choice to make is between arbitration and litigation. And it depends on a number of factors which most of us are familiar, include whether there is a need of confidentiality, whether there is a need of speedy resolution, and how the dispute resolution process can facilitate enforcement objective, and also the need of feasibility of fee arrangement. Apart from the typical arbitration and litigation clause, you may also consider so-called multi-tier dispute resolution clause or escalation clause, such as the parties are first to mediate or to negotiation first as a precondition to arbitration. In terms of the form of dispute resolution, obviously the ERAM is and should be one of the good choice. I would also want to advocate Hong Kong as one of the most popular dispute resolution center in the world. Hong Kong is constantly ranked amongst the world's top 3 as the most preferred seat for arbitration. And Hong Kong has our arbitration ordinance kept in line with the international standard. Recent amendments to our arbitration ordinance includes to allow flexible third-party funding, and also since last December, we have introduced the outcome-related fee structure arrangement regime in arbitration. Arbitral awards made in Hong Kong are enforceable in over 170 contracting parties under the New York Convention. And the unique advantage of Hong Kong arbitration is its connection with the mainland China. To date, Hong Kong has signed 9 arrangements of mutual legal assistance in civil and commercial matters with the mainland. These arrangements are broadly categorized into 3 areas, namely procedural assistance, arbitration, related assistance, and reciprocal recognition and enforcement jurisdiction. Hong Kong is also the only common law jurisdiction outside the mainland which enjoy the convenience and privilege of interim measures arrangement in the mainland, so that parties to arbitration seats in Hong Kong and administered by designated arbitral institutions can apply to the mainland courts for interim measures. These measures include preservation of properties, evidence, and conduct. And according to the figures of the DOJ, there are, as of the 31st of April 2023, the Hong Kong arbitral institutions have made more than 93 applications to the mainland courts. The majority of the applications, being 88 of them, involve the preservation of assets. so far, the mainland courts have granted 63 court orders to preserve assets of a total worth of RMB 15 billion. The take away from this is Hong Kong, and I would recommend all of you, if you so happen to have the need to draft dispute resolution clause, to consider Hong Kong arbitration clause as part of the dispute resolution clause. So this is the conclusion of my speech. Thank you.
Thank you so much, P.S. Indeed, it is so important to place enough emphasis on the sort of preparatory stage of, the contracts, commercial agreements, to make sure the parties actually do reach an agreement and there's enough certainty in the documentation that's settled. Now, I'd like to ask Billy a few questions as well. And if you don't mind, actually, I have a very basic question. Would you mind sharing with us what Legal Map does?
Actually, when I was asked to do this talk, they said it will be very brief. Someone will ask questions, and then we just casually answer. And then you have Thomas, the big slide, and then PS with 10 of pages. I was like trapped. Okay, but that's fine. Because I know we have a dispute here, and the topic is about dispute without borders. What's the dispute here? Because I'm your obstacle to your lunch. I know the feeling. As the last speaker and before the lunch, you want me to just finish it. And I'm very surprised because when I was still an in-house counsel, I used to come here every year and sit at the back to count who is sleeping. But not too many of you are sleeping. Very, very rare. I mean, this is maybe because this is the first one post-COVID, and we have the live event. And it's just great to see so many faces. Finally, I don't go out a lot. I usually stay in my home. And then the other thing which is so different from in the past is the technology advance. Besides the eBRAM is we have the screen. Before that, I can't see myself. So I thought I look okay. And I see myself is really fat. People say you're fatter, 10 pounds on the screen. I think, oh, how many cameras? I'm like 50 pounds fatter than myself. So for those on the Zoom, I'm actually not that fat. And then for the eBRAM, I have one question before I go on, is since now we have the deal making and we have other functions, will the name maybe change soon because we are no longer just dispute resolutions?
You're absolutely right. Thank you, Billy. You're absolutely right. It may well be an agenda item next time round for eBRAM to consider whether we should add in the deal making as part of our name.
Do you still take investment? Because it will be a unicorn very soon, so maybe we can chip in some money.
Well, let's look at it. Yes, welcome. Well, can I have your name card?
No, you have my mobile, and we can see each other at the ATM machine.
Yeah.
As well.
Okay.
Although we don't get a big paycheck as Thomas do in the past. But back to your questions. What was your question? Still have.
What is Legal Map?
Oh, yeah. We do
Thank
deal
you.
making. That's why the deal making part is really attractive. In the recent example, actually, we tried to convince the counterparty to use eBRAM, and then they refused. Actual example, just a few months ago, because they said, I don't know about this, and this is from Hong Kong, etc. It's an international thing. And then they insist on using Google Drive. I said, what? That's not safe. Everyone can have edit rights, and then people will share it. And they said, no, Google is safe. eBRAM is safer. Prove me. I can't prove you. Endorse it? No. Can you sign indemnity? Of course I won't. So that was the end of the conversation, and eventually everything on the Google Drive, I just downloaded myself, obviously, very happy. And that's wrong. So I think if with more education and then promotion, I'm sure we can start with the contract, and then since people get into a contract, then when they have dispute, they just come back. In between, you can do a lot of other stuff like alerts and things like that. I think that will be the real flow for us as I was an in-house counsel for many years as well. We will start with the contract, and as PS said, we may not have a choice. We just need to take the template.
you know, people will say, this is a template we stole from Clifford Chance. It's perfect. So how do you argue? So there is a clause, ICC arbitration is very expensive. No, this is for Clifford Chance, it must be good. So those are the difficulty we face sometimes when we get to the border place, when we are already very tired. We want to see our family. It's like in war in Iraq. You want to see your family, and there are still border place to negotiate. Okay, fine, whatever law, you know, the law of the mass, fine. I'll just sign it as long as you do the closing. So if we want to get it in, I think just give us more benefit. You know, sign up for the EBRAM clause, and then you get some free
Yes.
ice cream, something like that.
Well, I think at the moment, if you have a case that use EBRAM, I think there is a discount if the case is filed before the end of this year. So, yes, there will be a discount. But then back to your question, I think that at the end of the day, some people take, they are entitled to take certain view about Hong Kong and about what we do and about our legal industry and our dispute resolution industry. But at the end of the day, I think seeing and experiencing is believing. So, so it would be up to us. I think many of you sitting around here work for foreign companies, international companies, and you have every right and have every opportunity to speak out and explain to your boss or people around the world that Hong Kong, what your experience is about Hong Kong legal services and about our dispute resolution services. And if you try out EBRAM, if you think that it is good, you know, you would be entitled to speak out. And then, after all, customers have a choice, you know. Seeing and experiencing is believing. So if you use us, if you use the product, it is good. Compared with other institutions, I wouldn't say other institutions are bad, necessarily bad, because different institutions, different model serve different sectors and different types of cases. So, all I say is, you know, seeing and experiencing is believing. So try it out first, and then you can talk about your experience about using EBRAM.
Yeah, it's amazing for you and Nick to do this startup because of your, you know, you're not young, but great job. I mean, you know, Nick is a very busy person and Thomas too, and this is just unique. You don't see that in the legal world, and also it must be supported. I think we should put in a lot more contracts so that later,
Thank you, Billy.
later things
Thank
will
you,
flow
thank you.
back. And back to what Pierre said, I like his disclaimer. As a litigator, when you come to him, he said, no, avoid the legal things at all costs. You know, that tells everything, because he's very expensive. So later on, you can't complain about the bill. That's right? And so, no, he is not that at all. Very reasonably priced. But what I want to say is, in international elements disputes without borders, in fact, is not that different. I fly around the world. In Middle East, one time, I was there trying to solve a case, get into the car, and that guy, the local guy who actually take me to see the local lawyers, he said, okay, let's solve it in your way. If not, then I'll get my pistol. And then I opened that box, and there's really a pistol inside. Yeah, and actually, it's not that different, because at the end, it's just a joke. It was not real. All we want is to get back the payment. And so the greed, the unreasonableness is actually in every single place. But if we need to find the differences, whenever we go different places, I think people will use their own local culture to try to discourage you from doing your way. So that will be a challenge for us when you're in-house, and then you need to sometimes handle things in US, sometimes in Europe and in other places. You really need to travel a lot more in order to say, no, I understand that. Or maybe we need more diversity. You know, like the panel here, we're so not really diverse. But you know, sometimes we will need to have a more international team. And Hong Kong, I remember PS told me the other day, is in fact a very good bridge. You mentioned about that because we actually understand different things and so on. And so, do you think you sometimes in your dispute resolutions, your role is not just a lawyer, but you need to do the translation part, although we have the AI?
I think if I venture beyond the role as lawyer, it would become very dangerous in my experience and actual experience. There was a time which I have to travel outside jurisdiction with my client to have a board meeting with the counterparty to resolve a dispute. And at that occasion, I was essentially the mouthpiece of the client because the two parties, they speak different language. So I have to translate my client's speech to the counterparty. And so I was the mouthpiece. And the counterparty became so angry at my speech because I translate for my client. I got beaten up at the same occasion. I don't mind, actually, but it actually speaks of our role as lawyer. Don't become a mouthpiece for your client. Provide your legal service to client. Advise them what to say, what to do in a litigation or dispute. Do our job. Thank you.
Well, thank you so much for all the sharing. And let's resolve our dispute now because we need to remove that obstacle to everyone's lunch hour. Thanks, everyone, for coming to this session today. And thank you to all of our panelists.
Thank you all. Would our panelists please stay as the Law Society would like to present you a souvenir? May we invite Vice President Chris Yu to come onto the stage and present the souvenirs for us. Chris, please. May I just remind participants who have registered for the afternoon sessions to come back to sign in later again. Registration will start at 1:30 p.m. And if you have borrowed the audio devices, please return to the registration counter. Thank you, Chris. Thank you all our panelists. That's all for the morning session. We'll see you at 2 p.m. after the lunch break. Please enjoy.